Hi, good afternoon, everyone. Welcome back to Section 1 with your co-host, Stefan Ramkisoon.
And I'm Kyle Taklal Singh. Welcome, everybody, to Section 1. Stefan, we have an interesting program today.
On this cool, rainy Sunday afternoon.
Cool, rainy Sunday afternoon.
We have another jam-packed session yet again. In the forum, we're going to continue the discussion on the repatriation issue.
Yeah, very serious issue. I think we had a lot of people that reached out to us via Facebook.
Since the last program, we had a lot of inbox messages. A lot of people have been reaching out to us. And interestingly, in fact, Kyle, today we have two individuals who are stranded.
Yeah.
A young woman from the US, Soraya Kadir, and actually one from the United Kingdom who's stranded.
Stranded in the United Kingdom and in the US.
And in the US, yes. Jessica Kumal Singh.
Yeah, I think it's important, Steph, that we give some type of publicity and aid to these persons, let them speak out.
Yeah.
Hopefully, if enough people start speaking out and start raising their voices out against this injustice, the government and those who have the power to make the changes will, in fact, make the changes.
Correct. It will be interesting to hear what are some of the concerns they have, what are some of the problems they have been incurring since this has started.
And it has it. I think you have to put a human face to this thing now.
Exactly.
It's one thing to come here and
it's no
quote
longer
all the
theory.
law. It's one thing to come here and quote all the law and say what are the constitutional rights, but it's another thing to actually put a human face to the problem.
Correct.
And let us see what some citizens are going through. We encourage all other citizens who might be watching on the live stream on the Facebook to message, make your comments. We'll try to get through some of the comments today. Stefan forgot his laptop home, so we'll probably use the,
our cell phones
to do it. But
so once you have any questions that you have on the live stream, we will endeavor to answer those questions.
Yep.
On the deposition, we're going to tackle a very interesting topic, the Football Association versus the FIFA issue.
Yeah, was that a pun when you said tackle?
Well.
and
to have today, we have Mr. Matthew Gale, attorney at law. He was actually counsel for the Trinidad and Tobago Football Association, so we are very excited to have Matthew on, a colleague of ours.
It's very important, I think, for law in relation to both arbitration, which is, of course, an alternative way of settling disputes as to going to court.
Exactly.
And it's also important for sport law generally, I think.
The development of that jurisprudence is very important.
Very important in Trinidad, which is a really sport-loving nation.
Correct, correct. And then in the soapbox, we have two young ladies from Saraswati Girls Hindu College. They reached out to us, two different topics. Kyle and I, we very briefly looked at it, but our program manager, Larry, he chose the videos for today.
Yeah.
It's two young ladies, Yisha Mangal and Lily Ragunanan from Saraswati Girls. So we're excited to see what those two young ladies have to offer.
Very high-quality videos.
Yeah,
very
so let's move on. Yeah. Now, interestingly, this week we had very interesting topics.
Yeah.
Right? We had stemming from our discussion with Mr. Abood last time.
The Nabarima issue.
The Nabarima issue. We saw some developments there. Hopefully, once things get on the roll, what we can have is hopefully we can have Mr. Abood back on.
Yeah, well, what happened, I think, is that the government, so from what I've been reading, the government sent an expert team on to the Nabarima, and they have purported to do some type of assessment. I have not seen any written report come out of it.
Yeah.
There are some videos. Some people are accusing it, simply saying, look, that's propaganda.
Yeah.
Maduro-style propaganda, to put it that way. You put out a video, everything is okay. We don't know. We haven't gone on the boat. We can't judge.
Correct.
I think we need to see a report, and an authored report, and see the qualification of those persons who have produced this report.
For all those who missed last week's program, you would have, and you listened to what Mr. Abood would have been saying. It's a very important issue. And it's on the verge, as he would have stated, quote unquote, from Mr. Abood, it's an ecological disaster in the making.
Yeah, he's of the view that it's a very grave risk. Obviously, the government and the persons who went on the boat are of a different view. Maybe we could try to reach out to the government and see if someone could come and rebut what Mr. Abood said on the program. Or we have Mr. Abood back next week, and let's get an update.
I'm talking about that now. Interestingly, a topic that we find very important and we think is very important to our sovereign democratic state is the issue of in-person hearings in court, in-person trials in court. The whole issue that's surrounding that. Recently, the Chief Justice had issued practice directions to prohibit in-person hearings, which effectively means for you guys out there that trials will be held online or virtually.
Yeah, so usually I think everybody knows that, look, you have a matter in court, you go to court to deal with the matter.
Yeah.
Many of us have gone to court, you go, you sit down, you watch other matters, the judge calls your matter, your lawyer deals with it. And most of us have that experience.
Yeah.
I think what has happened, obviously, because of COVID, the Chief Justice has issued a directive, practice direction, basically saying no trials are to be held, no hearings are to be heard in
person, in court itself.
Now that presents a serious problem for trials, There are some matters, Stefan, as you know, that you could do on paper.
Yeah.
You do your written submissions,
Yeah.
you send it into the court could give its decision by email.
Yeah.
But there are other types of matters where you have both sides on a matter really having conflicting evidence.
Yeah.
One person say he entered through the door, another person say he entered through the window.
Correct.
And you have to have serious cross-examination to determine the truth.
Once there are sharp issues as to fact and what happened, what occurs in those instances, specifically in criminal matters, as you know, and in some civil trials, when you have those sharp issues as to fact, it is incumbent upon the advocate to bring out those issues,
well,
right?
It stems from your right of confronting your accuser.
Exactly.
Everybody has a right to confront their accuser, to face their accuser, as they put it in constitutional law. Now, that doesn't mean actually physically confront your accuser.
Exactly.
This isn't this isn't Game of Thrones where you have a champion and two of you fight it out with swords in a duel. That's not what it is. No. In fact, confronting your accuser essentially means that you must be given the ability to interrogate the evidence that is before you, scrutinize the documents that are being used against you, and to have your advocate or yourself in person actually cross-examine the witnesses that are against you.
Exactly.
And if you are able to cross-examine the witnesses, you might be able to show up inconsistencies. You might be able to show up where they're lying and put your case to them.
And importantly, in trials itself, there is a responsibility of the judge to assess the credibility of the witnesses.
And that's a huge thing, because oftentimes when you read judgments, you would see that the judge would look at the demeanor of a witness.
Correct.
They would look at the way the witness answers, the way whether he's fidgeting in the box, and say, look, I trust this witness, or I don't trust this witness.
So a lot of those who are going against in-person trials, I mean, we know it because we are attorneys who are practicing in the courts. A lot of people that are going against these in-person trials, it stems from these issues that we're bringing up. How is it? So some of the proponents would have been, some of the people who are against this would have said, look, how is it that a judge is supposed to can they properly assess the credibility of a witness?
You actually had one judge this week making comments as to the fact that he couldn't continue.
Well, he stopped, actually, you're right, he stopped the entire trial.
He stopped the trial. He couldn't continue because of challenges with the internet.
A civil judge at that.
A civil judge at that. He had challenges with the technology. And you can't fault a judge.
Correct.
Because a judge wants to assess witnesses, you want to assess arguments. You may want to interact, even if it's purely a case on arguments, you want to interact with the lawyer. So it should not be looked at as a very light issue, I think. It should not be just passed over. Having a trial in person is a very important part of the justice system, a very important part of the administration of justice, and a very important part of the rule of law, ultimately.
That is important.
Yeah,
that is important.
You have to be able to face your accuser. And that issue of cross-examination is very important. The very essence, there was a case, Jones versus the coal board.
Lord Denning.
Lord Denning actually said that the way to test evidence is through cross-examination. And the very nature and gist of cross-examination is in the unbroken sequence of answers and questions.
Exactly.
And when you have this virtual hearing, I mean, we know the technology is advanced, but sometimes, and I have had the situation where you're speaking to someone either on Zoom or through one of the other software, and you ask something and there's a pause, and then the person answers. And what that does for cross-examination, as you know, Stefan, if you're cross-examining a witness, you want to be on him. You can't give him time to think. You can't give him time to think up a story and it's very easy for someone to simply say, oh, I'm not hearing you. Could you repeat that again?
Correct.
You broke up, and all this while they're thinking.
I mean, very recently, Kyle, I was in a hearing, not a trial, but a hearing before a judge, a civil judge. And electricity went out of our chambers.
Right. Yes.
And what I had to do was use my phone to zoom back into the conversation. It disrupted everything, and this was a regular case management conference. Could you imagine if I was cross-examining a witness?
And let's say you had the witness on his back. You had him on his heels, and you're pressing him, and then you have a break in technology.
It goes against, as you say, the proper, I think, administration of justice. I think the DPP would have, within his forum with his officers, they are not really doing a lot of in-person trials at this point.
For what I've observed, but certainly there's an issue. I do not think that the technology facilitates, in my view, cases where you need that type of hard-edged cross-examination. And I think it's wrong to force someone to have his trial heard in that way, quite frankly. And I think I see that Senior Counsel Sophia Choate has actually raised the issue in a criminal matter. It's reported in papers. She's raised an issue about it. She's made submissions. Of course, the matter is sub judice, so we can't talk about the facts.
Yeah.
But she's raised that legal issue, and I think the judge is going to rule on it. So maybe, Stefan, next week we could probably try to have some guests on to specifically deal with that issue.
And what I want to make very clear, the virtual system implemented by the government and the judiciary recently, by all accounts, it has been very good in terms of the case management conferences, appeals. Kyle and I, we have been subject to about 2 or 3 appeals, heavy appeals, where it went smoothly. And I think the judges, in terms of case management, in terms of appeals, hearing oral submissions, it is good.
So
but we are specific in terms of in-person hearings.
You have to have the right mix.
Yes,
I think that's,
exactly.
at the end of the day, that's what you have to do. You have to strike the right balance. Technology is good. It's certainly good for certain things. Procedural hearings is very convenient. You don't have to leave your office to head to court, wait an hour for a hearing, and then come back, and then you lose a couple hours. And then the client has to pay for that because ultimately it's your time.
And it's very convenient to you, the public. When you have an attorney, you could stay home at what we have right now. You could be at home. The judges, the magistrates, they are very accommodating. You don't need to be at the lawyer's office. And we facilitate that now, the virtual hearings. And by all accounts, it has been a very successful rollout.
So I do think the technology will play an important part in this issue. But I think for certain things, especially with trials and especially where judges need to interact with lawyers on a heavy or in a very concerted way, I think that it is not optimum at this point.
Now, something that we are seemingly overlooking, it just occurred to me. What we seem to be overlooking is the small practitioner, the small lawyer, the lawyer who has a small office. We know in chambers sometimes you have attorneys who share cubicles, share when I now came out, when I entered my first chambers, I was sharing a desk with someone. How is the issues that we're going to have now is how are we to properly ascertain how
I could see that leading to a type of inequity in the profession, because you have lawyers who operate out of very small offices. Some lawyers would operate out of places where you don't have that bandwidth. The bandwidth is not consistent. So how are they to survive? How are they to sustain themselves? And these very young lawyers who are now starting up their chambers, who are now starting up their practice, often operate in these small types of offices, these small setups. I started there, Stefan, you started there. Most of the prominent lawyers in the country started in
at very small offices.
And they could have ordinarily gone to court and do their cases without issue. But now if you're going to have them conduct a trial in a cubicle or in a very small space, you're putting them at a disadvantage. So I think that's something that the judiciary needs to look at. Because what you're going to have is now people only going to the bigger firms and bigger chambers because those firms and chambers have the facilities,
the technology to facilitate this new rollout. And again, I want to stress upon it, my experience thus far with the virtual system has been great. It has been great. We have matters throughout the country, and what happens is you sit at your office and you have a matter in Rio Claro, Mayaro, Port Spain, San Fernando within a space of about 2 hours.
Well, generally, I am incompatible with technology.
We know that.
We know generally, that. Generally, I'm incompatible with technology.
We know that.
But I've been even for me, it's not been very bad. I've been able to cope. A few times, I think I was caught having casual conversations while the judge was logging on.
I remember that.
But everyone has to get accustomed to it, and I think people will get accustomed to it eventually.
I'm very happy that we brought up that topic. I think it was a topic that we think needed a little bit of discussion.
I think we need to go into it a little more. So probably next week we could have some students send in some videos on it, what they think about it.
In-person trials specifically.
And we could get some guests, some appropriate guests.
So at this point in time, we want to take a very, very short break, and we're going to come back with the forum and continue the discussion about the repatriation of our citizens.